My next case is Citizens for a Safe Chatham Airport versus the Town of Chatham. Citizens for a Safe Chatham Airport and 3 individuals who own real property in close proximity to the airport are seeking to prevent the resumption of skydiving activities at the Chatham Airport. They're asserting claims for nuisance and declaratory judgment and requesting the Superior Court enjoin Chatham from entering into a contract with a skydiving vendor. Skydive Cape Cod, Inc., also known as SDCC, began operating a full-time skydiving business at the airport pursuant to a vendor contract. Citizens at this time began viewing skydiving as a nuisance due to noise and safety concerns. Citizens claim that these skydiving planes were unique because 1, the skydiving planes flew more frequently and were louder than other planes, and 2, skydivers screamed, and in particular, screamed many profanities during the course of their jumps. Citizens also claim that skydiving creates a risk that skydiving planes and skydivers will crash or land on their property. Citizens used evidence showing that SDCC took safety risks that resulted in one of SDCC's planes crashing in a nearby lake, and skydivers sometimes, although infrequently, landing off-site or having near misses. Citizens voiced their complaints to the town, which declined to approve the SDCC vendor contract in 2013. After the town declined to renew SDCC's vendor contract, SDCC filed an administrative complaint with the FAA, claiming that Chatham was violating its obligations under the FAA grant agreement. In exchange for receiving federal grant money for airport improvements, the town agreed to make the airport available as an airport for public use on reasonable terms and without unjust discrimination to all types, kinds, and classes of aeronautical activities. SDCC claimed the town was violating the assurance, which was Assurance 22. The FAA's Regional Airports Division commenced an informal investigation pursuant to 14 CFR Part 13 and found the town was in non-compliance with the Assurance 22 by unjustly discriminating against the aeronautical activity of skydiving. To resolve the non-compliance issue, the town agreed to issue a request for proposal for skydiving services. These were due by November 30th, 2015, and the town received 2 responses, including one by SDCC. Next. Chatham asked the FAA to assess whether skydiving could occur safely at the airport. The Airports Division reviewed 14 risk factors and determined that 12 out of 14 of the risk factors were low risk. They proposed mitigation measures to reduce the other 2 risk factors and concluded from a safety perspective that it was feasible for skydiving to occur at the airport. The Superior Court judge concluded that the citizens' claims stemming from Chatham's contract for skydiving concessions at the airport must give way to conflicting federal law, which requires Chatham to enter into such contracts. The court here does not address preemption. Instead, they address the rightness doctrine, which requires them to ask whether the alleged injury has matured such that it is no longer hypothetical or speculative. If an injury is imminent, that is enough. We need not wait for the consummation of the threatened injury to obtain preventative relief. There is nothing here to infer the alleged injuries, such as noises, plane crashes, and off-site landings are imminent. Citizens' only evidence here are noises and safety concerns that occurred with SDCC nearly 10 years ago. The court also makes a point that at this stage, the court does not know whether skydiving operations will resume at all or under SDCC. And where they do not know the vendor, if any, they do not know information such as hours of operation, how frequently flights will run, or any other information that will allow them to conclude that the same alleged problems with noise will occur. Another vendor could adjust the safety of its operations. Whether skydiving will resume, and more importantly, will upon its resumption create a nuisance, is dependent on facts that have yet to occur. Whether it is entirely possible that the alleged injuries may not develop, the disagreement between the parties is abstract, hypothetical, and speculative, and the claims are not ripe for review.